Objection to the Bloom v. City San Diego case, 5/27/2024. Your Honor, this objection addresses significant ethical concerns regarding the proposed settlement in the Bloom v. City of San Diego case. Despite acknowledging the attorney's efforts in advocating for homeless rights, the settlement proposal fails to meet essential standards of justice and equity. This is for all the people who have been victimized by criminal authorities. Key points of objection: lack of accountability for unconstitutional actions. The city faces no consequences for its unconstitutional conduct, perpetuating injustice and relying on public ignorance to deprive the homeless population of their fundamental rights. Number 2, inadequate representation and breach of duty by attorneys. Attorneys have failed to vigorously defend their clients' inalienable rights and have settled without addressing the city's unconstitutional actions. Failure to file for necessary injunction relief has resulted in ongoing harm to class members, including the impoundment of vehicles, which destroys the quality of life. Number 3, financial disparities and ethical concerns. The settlement provides substantial compensation to attorneys, $3 million, while offering minimal relief to the plaintiffs, nominal $22,000, raising concerns about prioritizing financial gain over clients' interests. Number 4, short-term solutions ignoring long-term impact. The proposed 3-year temporary relief does not address the long-term deprivation of civil rights and systemic injustices caused by the ordinances. Number 5, misapplication of the law. Sex offender ordinances applied to non-sex offender homeless individuals. Referential sex offender status, punishment, and restrictions applied to non-sex offender homeless individuals by OVO and VHO ordinances. The settlement imposes the same punitive measures on non-sex offender homeless individuals that are disproportionate and akin to those imposed on sex offenders. This comparison underscores the egregious nature of punishment faced by homeless individuals simply for seeking shelter in their vehicles, highlighting the unconstitutional nature of the ordinances and thereby injustice being perpetuated by their enforcement. Number 6, discrimination and segregation. The enforcement of OVO and VHO ordinances result in discrimination and segregation of homeless population. This enforcement forces them into segregated parking lots or shelters, thus marginalizing a socioeconomically disadvantaged group and treating them as a second-class citizen. These practices deprive individuals of their dignity and fundamental rights, fostering an environment of exclusion and inequality by the City of San Diego, promoting socioeconomic imbalance, class prejudice, and hatred. Number 7, prejudicial permitting practices. The city's permitting system for oversized vehicle parking privileges only the city's permitting system for oversized vehicle parking privileges only benefits residents with addresses, thereby excluding homeless individuals who lack permanent addresses. This discriminatory practice further exacerbates the marginalization of the homeless community by denying them the same rights and privileges available to those with addresses. Number 8, inadequate remedy for homeless crisis. The city's reliance on punitive ordinances, the OVO and VHO, rather than sustainable housing solutions exacerbates the homelessness crisis and violates the plaintiff's constitutional rights in favor of a continual income stream for the city. Proposed settlement. To rectify these injustices and uphold justice, equity, and constitutional rights, we propose the following comprehensive remedy. Number 1, immediate declaratory permanent injunction relief. Implementation of permanent injunctions against the enforcement of OVO and VHO ordinances. Number 2, total legal remedy of $700 million in compensatory damages. General damages. Compensation for illegal civil asset forfeiture. Special damages. Compensation for loss of personal property and life-sustaining equipment. Consequential damages. Compensation for psychological and physical harm from deprivation of rights. Incidental damages. Compensation for breach of contract and negligence in upholding constitutional rights. Punitive damages. To ensure the city no longer uses punitive measures to address homelessness. Restitution. Reinstatement of clean license plates, driver's licenses, and registration suspensions. Number 3, creation of sustainable housing programs. Establish transparent and accountable housing programs funded appropriately, ending exclusive funding for homeless policing. Number 4, ticket forgiveness and property recovery. Forgiveness of all tickets issued under the OVO and VHO, and access to nighttime parking for currently restricted parking on public streets and parking lots. Recovery of impounded property. Number 5, accountability for city officials. Holding city officials legally accountable for unconstitutional actions leading to the deprivation of plaintiffs' rights. Number 6, elimination of unconstitutional ordinances. Immediate cessation of any practices that criminalize the homeless population or violate individual civil rights. Request for action. We request to have the Bloom versus City of San Diego settlement proposal objected, and this new settlement proposal implemented, or we request trial. Conclusion. The proposed settlement in the Bloom versus City of San Diego case fails to meet ethical and legal standards. It is imperative to advocate for a remedy that truly reflects justice, equity, and constitutional rights. We urge the court to consider these objections and ensure a just settlement that addresses the extensive damages suffered by the plaintiffs and prevents future harm. Your Honor, we respectfully request the court to uphold these objections and advocate for a settlement that embodies the principles of justice, equity, and constitutional rights for all affected individuals. Considering this, progress towards trial, if not proposed resettlement, is logical. Respectfully yours, Christopher Scott Enders.